Good evening and welcome to UCL Virtually. I am Dr. Danae Azaria. I am Associate Professor and co-convener of the ILA lecture series at UCL Laws. It is a great pleasure to chair tonight's ILA lecture by Professor Philippa Webb, who is Professor of Public International Law at King's College London and the author of numerous major publications in the field, including her more recent book on the right to a fair trial in international law, which she co-authored with Amal Clooney. The title of her talk tonight is The Right to a Fair Trial, From Assange to Gone. The subject is never far from the news headlines, and it is significant, especially given that the right to a fair trial works as a guarantee for so many other human rights. Before I pass the floor to Professor Webb, I want to draw your attention to the chat function where you will find a discount code for the book. And you can also place your questions in the Q&A function during and after the talk. And so the floor is now yours, Philippa.
It's really a pleasure to participate in this lecture series, even if virtually. So the right to a fair trial is at the heart of human rights protection. An unfair trial can be devastating. It can remove your liberty, destroy your reputation, and in some states, take away your life, as we've recently seen with the resumption of executions in the last days of the Trump administration. Unfair trials are also damaging to society as a whole by undermining democracy or oppressing minorities. Now, we're all aware of politicized prosecutions, but what is perhaps less visible is conviction rates. In a properly functioning criminal justice system with strong defense rights, a substantial proportion of trials should end in an acquittal. But in China, 99.9% of defendants are convicted. In Russia, 99.3%. Japan has a conviction rate of 99%, a point I'll come back to. In the United States, it's 90%. And in England and Wales, it's over 80%. In many systems, the vast majority of defendants never even go to trial due to guilty plea agreements. In the United States, 97% of all convictions result from such pleas. And a low conviction rate for certain types of defendants can also be a red flag. In India, the overall conviction rate of 40 to 50% drops to only 6% in cases where the defendant is a politician. So as Danae mentioned, last month, Amal Clooney and I launched our book published by Oxford University Press on the right to a fair trial. And I just have it here as heavy evidence of all the work. The hardcover will be coming out on Valentine's Day. And I know that in the chat, there's a discount code you can take advantage of. This book arose out of our realization that despite the importance of the right to a fair trial, most leading human rights textbooks don't even include a chapter on it or don't engage in detailed analysis. And existing academic studies tend to focus on only one or two sources. So this means that counsel in domestic courts don't tend to cite an international standard for a fair trial, but they focus on national case law or a provision of a regional treaty. So the purpose of our book is to be both universal and practical. We want to bring to life the commitment made by over 170 states that have ratified the International Covenant on Civil and Political Rights. The right to a fair trial is the most litigated human right in the world before international courts and UN bodies. More than half the cases filed before the Human Rights Committee concern Article 14, which enshrines the right to a fair trial. And at the European Court of Human Rights, 49% of cases involve fair trial violations, more than double the number of cases that invoke any other human right. So in our book, we explain what the right to a fair trial means. We compare Article 14 of the ICCPR to provisions in other treaties. We examine the Travaux, and there will be coming out in a few months our collection of the Travaux as a book as well. And we assess how these provisions have been applied by international bodies, including UN committees, regional human rights courts and commissions, and international criminal courts. And we had, of course, we couldn't do this on our own, and we had superb assistance from very talented researchers. So today I want to highlight 4 issues relating to the right to a fair trial. First, how these issues have arisen in high-profile cases. And the title of my talk, when I chose it a few months ago in response to Danae's invitation, mentioned Ghosn and Assange. But I think we can add to that list now Navalny, and I'll say a little bit about him. I will then talk about the status of the right in customary international law, who enjoys the right apart from the defendant, and fragmentation in the law and potential methods of harmonization. So turning first to high-profile cases. 3 days ago, the leading critic of Putin, Alexei Navalny, was detained minutes after he arrived at Moscow's airport from Berlin, where he had been recovering from being poisoned in Siberia last August. On Monday, he appeared at what was called an ad hoc hearing, which was held not in a court, but in a police station outside of Moscow. And in a video posted to Twitter, Navalny said the following: "I came here and here is a court session taking place. Why is the court session taking place in a police station? I cannot understand. Why was no one informed? I've seen a lot of jokes about the judicial system here. It's not possible what is happening here. It's the highest level of lawlessness. I cannot call it any other word." He is now remanded in custody for 30 days at least. The UK Foreign Secretary Dominic Raab said that it is appalling that Alexei Navalny, the victim of a despicable crime, has been detained by Russian authorities. He must be immediately released. And other leaders and foreign ministers around the world have echoed those calls. But the general public is probably not that surprised to hear of fair trial violations in Russia or in North Korea or Iran. But the reality is no state has a spotless record of conducting fair criminal proceedings. So until the former head of Renault, Nissan, Mitsubishi, Carlos Ghosn, dramatically escaped from house arrest in Japan last December, hidden in a musical instrument case, you were probably not aware of the critiques of the Japanese criminal justice system. Some of those critiques include long periods in jail before going to court. A defendant or an accused can be held for 23 days, renewable without charge. Interrogations that take place without counsel present, the denial of family contact, and that 99% conviction rate that I mentioned. Last November, the UN Working Group on Arbitrary Detention adopted an opinion concerning Carlos Ghosn. It emphasized that it expressed no view on the circumstances in which he fled the jurisdiction of Japanese authorities. But they did comment on the presumption of innocence, which is one of the key components of the right to a fair trial. They noted that when the prosecutor came to arrest Carlos Ghosn, he came accompanied by journalists and photographers. And when Ghosn appeared in the Tokyo District Court, he was handcuffed and tied at his waist with a rope. They said, the working group, that criminal defendants should not be presented to the court in a manner indicating that they may be dangerous criminals. The working group also found violations of Article 9 of the ICCPR related to the 120 days in detention with regular interrogations that took place without Ghosn's lawyers present. It also found that his detention was arbitrary under categories 1 and 3. The appropriate remedy, according to the working group, was to have an enforceable right to compensation and other reparations, and they urged Japan to investigate the circumstances surrounding Ghosn's detention. And I now turn closer to home, to the proceedings concerning Julian Assange. The indictment against the WikiLeaks founder has alarmed journalists at newspapers around the world. As the editor of the Washington Post put it, the indictment criminalizes common practices in journalism that have long served the public interest. Media freedom advocates argue that Assange's conviction would make an offense of cultivating sources to reveal information that exposes incompetence, corruption, and illegality. Assange faces 17 espionage charges and 1 charge of computer misuse over the publication of classified US military documents. This could result in a sentence of 175 years in prison. And everyone was waiting to hear yesterday and today whether outgoing President Trump would pardon him, and he didn't. So even in his last hours in office, and I think 150 or so pardons or orders for clemency, no mention was made of Assange or Snowden. As you also know, 2 weeks ago, Assange's extradition to the United States was blocked by an English court. But it wasn't because of these freedom of expression issues that I've mentioned, but on the grounds that he would be held in prison conditions in the US where a risk of suicide was substantial. In the words of the judge, I find that the mental condition of Mr. Assange is such that it would be oppressive to extradite him to the United States. But I want to go back a few more months, not to this decision on extradition, but to the 4-week extradition hearing in the Old Bailey, because that's where we saw some fair trial issues arise. Now, I was not in the courtroom, but what was reported by those few who could be in the courtroom given pandemic conditions was concerning. And I'm just going to highlight a few points that have been raised, in particular by civil society. So first, there's the right to a public trial. Very few seats were available in the public gallery of the overflow courtroom. NGO observers from Amnesty, for example, were treated the same as the general public. No allowance was made for their remote monitoring of proceedings. They had to queue from the early morning, I think 5 a.m., to gain access to the 4 spaces, the 4 chairs allocated to the public. In the overflow courtroom, there was a small television screen across a large room, so it was not possible to see who was speaking or even whether the judge was sitting and present. It was also possible to follow the proceedings by telephone conference. It wasn't streamed online, but there's been complaints about the poor audio quality and people being unable to follow the evidence. The next issue is the right to counsel. Now, Assange, of course, was well represented, but he was held in a glass enclosed dock for the hearings. And he said that he was struggling to hear what was happening, and he also could not easily communicate with his legal team from the dock at the back of the courtroom. And then we have the right to examine witnesses. So hours of scheduled witness testimony were apparently lost due to the court's inability to connect witnesses remotely via video. Now, we all know the challenges of online teaching, holding online conferences, but when it comes to fulfilling someone's human rights, one would hope that greater care would be taken. At one point, the audio feed to the courtroom cut out for around 10 minutes, meaning that the press and observers missed an important argument over whether evidence from a defense witness would be accepted or not. So the takeaway from these high-profile cases, which are selective but are also not entirely unrepresentative, is that we should not be complacent about our criminal justice systems, even in stable democracies that respect the rule of law. If the trial of a high-profile defendant who has access to the media, who has NGOs monitoring their treatment, and yet still has proceedings that raise such issues, imagine the problems faced by ordinary defendants. And to give just one example that came out this week in a BBC report, the right to be tried without undue delay is being undermined by COVID-related delays in proceedings. So the backlog in the Crown Courts in England and Wales has reached 54,000 unheard cases. Now, the vast majority of those cases are for less serious crimes, but as that backlog grows, so does the number of people on remand in prison awaiting trial, and they now represent more than 15% of the prison population. So now I come to my second point, which is the status of the right to a fair trial in customary international law. There has been little analysis of the degree to which the right and its components has achieved customary status. In our view, in the book, there's strong evidence that the right as a whole, as well as most of the 13 component rights in Article 14, have achieved customary status. And let me just quickly list those component rights so you understand what I'm referring to when I say it's not just one right, but really all of these different aspects. So there's the right to a competent, independent, and impartial tribunal established by law. There's the right to a public trial, to the presumption of innocence, both of which I've mentioned, to prepare a defense, to counsel, to be tried without undue delay, to be present, to examine witnesses, to an interpreter, to silence, to appeal, to equality, and the right not to be subject to double jeopardy. The right to a fair trial appears in all the major human rights instruments, in numerous military manuals, and in the statutes of all the international criminal courts. And even states that are not party to the ICCPR have codified fair trial rights in their domestic legislation, such as China. It doesn't mean that they respect it, but they have codified it, showing some sense of legal obligation. The ICRC has said that state practice establishes that the right to a fair trial is a norm of customary international law applicable in both international and non-international armed conflicts. And the ICTY Appeals Chamber has affirmed that the right is, of course, a requirement of customary international law, and the Inter-American Commission has said the same. In the book, we look at the confirmation that the right is also non-derogable. And even though the right is not included in the list of non-derogable rights in the ICCPR, the Human Rights Committee has said that states parties may in no circumstances invoke Article 4 on derogations as justification for acting in violation of humanitarian law or, and I quote, peremptory norms of international law, for instance, by deviating from fundamental principles of fair trial. And some even consider the right to a fair trial to be a jus cogens norm. One of the most famous proponents of that view is Judge Robinson of the ICJ. So that's the right as a whole. But there's also evidence that many of the 13 component rights of the right to a fair trial in Article 14 have themselves, in and of themselves, achieved customary status. And of the component rights, we conclude that the right to a public trial and the right to translation, which is an aspect of the right to an interpreter, are potentially derogable, but the rest are non-derogable. So now I come to my third main point. Who enjoys the right to a fair trial? There are several components of the right that are clearly applicable only to the defendant in domestic courts. The right to prepare a defense, the right to silence, the right to counsel, and the right to appeal a conviction or sentence. But there are also certain rights that affect others who are party to or impacted by the trial process, victims and witnesses. And there are rights that are important to the general public. And sometimes third-party interests overlap with the defendants. Victims, witnesses, and the defendant may all wish for a trial to be held in public or for it to be concluded within a reasonable time. I just mentioned the statistics on delays in England and Wales at the moment due to the pandemic. And what also came out of that research is that defendants and victims alike are concerned about delays leading to witnesses forgetting events that took place months or even years ago. And there's also evidence that these delays are causing stress and anxiety. The report mentions a victim of domestic violence who brought the claim in the summer of 2019 and now has had the trial against the alleged perpetrator delayed until 2022. And she wrote an open letter about her experiences, and she says as follows: "The nightmares have increased in frequency, and it is becoming very difficult to be able to enjoy anything. I am so desperate to move on, I feel utterly powerless to do anything about it." Other scenarios may bring interests into conflict. The defendant's right to cross-examine may have to be balanced against the interests of vulnerable witnesses. And some rights are crucial to the public's confidence in the criminal justice system. Having a competent, independent, and impartial tribunal, of course, the presumption of innocence, and equal treatment under the law. So if we accept that the right to a fair trial, although principally for the defendant, is not exclusively for the defendant, then two issues arise. First, the extent of the recognition of a non-defendant's interest and if it can be said to amount to a separate right. And second, what to do when it conflicts with the right of a defendant. So the Inter-American Court takes a particularly expansive view of victims' rights. They have said that the victims of human rights violations or their next of kin should have wide-ranging possibilities of being heard and taking part in proceedings in order to clarify the facts and punish those responsible and to seek due reparation. And the court has also applied specific fair trial rights to victims and their relatives. So, for example, the right to be present has been interpreted by the Inter-American Court to include the right of victims and their next of kin to take part in all stages of the proceedings so that they can make proposals, receive information, provide evidence, submit arguments, and otherwise assert their rights. The Inter-American Court has also found that the right to an interpreter, which we usually think of as an interpreter assisting the defendant in understanding proceedings, the Inter-American Court found that that right had been breached when a victim was unable to file her criminal complaint in her own language. International human rights bodies have also recognized the role of witnesses in fair trials, emphasizing the need for their protection, but also balancing their interests against those of the defendant. And some international bodies even refer to the right of a prosecutor to a fair trial. For instance, the ICCPR appeals chamber, in finding that a trial chamber had erred in excluding certain evidence, observed that the application of a fair trial in favor of both parties is understandable because the prosecution acts on behalf of and in the interests of the community, including the victims. And the Special Tribunal for Lebanon has also expressly recognized the prosecutor's right to a fair trial. On the other hand, the ICC has declined to recognize that the prosecutor is protected by the right to a fair trial. They've said that it is commonly understood that the right to a fair trial in criminal proceedings first and foremost inures to the benefit of the accused. So what about addressing conflicts between the rights of defendants and the rights or interests of non-defendants? There is a potential here for a conflict to arise. And international human rights bodies have developed a number of techniques to resolve such conflicts. They engage in a balancing of interests. They might consider that the defendant's right should be subject to the measures adopted for the protection of victims and witnesses in some cases. They may require the defendant to exercise due diligence in asserting a right, or they may prioritize not causing prejudice to the rights of a defendant. So one example is the duty to investigate and prosecute. So although the ICCPR imposes an obligation on states to investigate and prosecute alleged human rights violations, the UN Human Rights Committee has found that the right to a fair trial does not necessarily provide for the right to see another person criminally prosecuted. And the European Court has also found that the right to a fair trial does not include a right to have criminal proceedings brought against a third party with a view to securing their conviction. But the Inter-American and African courts have found that violations of victims' and relatives' rights to access the courts when the authorities have failed to investigate and prosecute perpetrators of human rights abuses. So they've been much more willing to favor the victims and relatives aspect of that right. So now I come to my fourth point, which is the fragmentation and the methods of harmonization of the right to a fair trial. And I've already, until now, pointed out a few examples where you've seen international human rights bodies diverging in their approach. And the reality is many states are subject to more than one international instrument and regime for monitoring and holding states accountable for fair trial violations. So all 47 states that come within the jurisdiction of the European Court and the 21 states under the Inter-American Court's jurisdiction have also ratified the ICCPR. And all 9 of the states that have recognized the competence of the African court to receive cases from NGOs and individuals are also states parties to the ICCPR. And the Working Group on Arbitrary Detention can act on petitions from individuals anywhere in the world. So while international bodies have admissibility rules designed to avoid duplication, claims concerning similar issues can and do come before multiple jurisdictions. So, for example, the politicized prosecution of the former President Nasheed of the Maldives came before both the Human Rights Committee and the Working Group on Arbitrary Detention. And this was a trial, a domestic trial that had been riddled with fair trial violations. So 2 of the 3 judges that had presided over his case had acted as witnesses for the prosecution in earlier proceedings. The trial started the day after his arrest, which severely undermines the right to prepare a defense. And he was not allowed to be represented by counsel of his choice because under the domestic law, 2 days were required for the counsel to register, and he was only given 1 day before his trial started. So both the Human Rights Committee and the Working Group looked at these violations. And the Human Rights Committee did allude in passing to the earlier Working Group opinion, but it imposed different remedies. The Working Group recommended the immediate release of President Nasheed and compensation, whereas the Human Rights Committee found that the Maldives was obliged to quash his conviction, to review the charges, and if appropriate, to conduct a new trial, to restore his right to stand for office and to take steps to avoid similar violations in the future, including reforming their laws. So a much more complex suite of remedies, but missing out the remedy that probably mattered most to him, which was release. Another example. In another case, a lawyer was prosecuted by Portuguese authorities for allegedly insulting a judge. And he was assigned a lawyer to represent him, but he, as a lawyer himself, wished to defend himself. The Human Rights Committee found a violation of the right to self-representation, which is an aspect of the right to counsel. But when the same case came before the European Court, it declined by a narrow majority to follow the Human Rights Committee. It said even where the provisions of the Convention and those of the ICCPR are almost identical, the interpretation of the same fundamental right may not always correspond. So they found no violation of his right to counsel. Fragmentation may be explained by the different features and procedures of the international bodies that are interpreting, applying, and developing the right to a fair trial. So at one end of the spectrum, we have the European Court. It has 11,000 judgments on fair trial issues. It has detailed reasoning and very specific remedies. At the other end, we have the African Court of Human and People's Rights. It's delivered only 35 judgments with fair trial aspects, but it's only been in operation for 14 years. The Inter-American Court is in the middle with around 300 decisions on fair trial issues over 4 decades. As I've already mentioned, they pay particular attention to the victims, to their relatives, and they often have quite creative and wide-ranging remedies. And then we have the Human Rights Committee, which has issued over 850 decisions on Article 14 since 1976, and it requests or recommends rather than ordering states to remedy a violation. And unlike the regional courts, it almost never hears oral argument. So in this legal landscape, the potential for fragmentation is very real, but it has been limited in practice. And just to give you a few examples of the law diverging. On the right to silence, there are divided views on whether adverse inferences can be drawn from a defendant's silence. The Human Rights Committee, regional bodies, and international criminal courts do not permit the drawing of an adverse inference of guilt, but the European Court allows such inferences in some circumstances. On the presumption of innocence, the European Court has found that this presumption does not apply during the sentencing phase of a trial, once there's already been a conviction. But the Inter-American Commission has reached the opposite conclusion. On the right to interpretation, the European Court expects national authorities to proactively ascertain whether a trial requires the assistance of an interpreter. But other human rights bodies only require an interpreter to be provided to a defendant when the court is somehow put on notice that the defendant is having trouble following the proceedings. And on the right to appeal, instead of requiring a review of law and fact, conviction and sentence, the European Court allows appeals to be restricted to points of law or the sentence only. Fragmentation also occurs in respect of remedies, as I've already pointed out with the Nasheed case. Imagine that you were detained after an unfair trial. The remedy that would be foremost in your mind is not a few thousand euros in compensation to be received in 10 years, but would be release from your situation. But that is also the remedy that is most intrusive on state power. The working group has ordered release in the vast majority of cases where it found a detention to be arbitrary. The Human Rights Committee has recommended some form of release in about 69 out of 262 decisions on fair trial violations. But out of the very large number of fair trial cases at the European Court, it only ordered a state to release a defendant in 2 cases to date. And despite the Inter-American Court having quite an activist approach to remedies, it has only ordered the release of a defendant in 2 out of 160 cases. So how can we enhance integration and harmonization among the international bodies? There's no one single principle that will resolve conflicts of interpretation, and different bodies prioritize different approaches. So the Inter-American Court has taken what it calls a corpus juris approach, meaning that it refers to other instruments and to jurisprudence of other bodies to take into account developments in the corpus juris gentium of international human rights law over time and in present day conditions. The African Court and the African Commission also regularly refer to other international human rights sources in their decisions. And in fact, the African Charter on Human and People's Rights expressly calls for drawing inspiration from international law. And without actually using the term corpus juris, the Human Rights Committee and the Working Group occasionally refer to other international instruments and case law. But even though the European Court of Human Rights is the court of reference that all the other bodies look to, it itself makes very limited reference to the jurisprudence of others. And you could say it remains relatively self-contained. Another method of harmonization is the pro persona principle, which means that no provision of a treaty may be interpreted as restricting the enjoyment or exercise of any right or freedom recognized in national law or another convention to which the state is a party. And this is codified in various treaties. A related principle that you would have heard of is in dubio pro reo. This is in the ICC statute, for example, which means that the definition of a crime shall be construed and shall not be construed strictly and shall not be extended by analogy. In the case of ambiguity, the definition shall be interpreted in favor of the person being investigated, prosecuted, or convicted. And the European Court has sometimes harmonized the European Convention with a higher standard on the basis of the effectiveness principle, meaning that an interpretation that would render an individual's right ineffective should not be adopted. Other principles place greater emphasis on predictability in lawmaking. So the principle of systemic integration from the law of treaties calls for the interpreter to take into account any relevant rules of international law applicable in the relations between the parties. And this has been invoked by the European Court occasionally and by the International Court of Justice. And Amal and I argue in our introduction to the book that when a conflict exists, a simple solution would be for the most extended protection to prevail as the international human rights standard, recognizing that this may, in some cases, clash with the rights of non-defendants, including potentially victims. But this most extended protection approach would be in keeping with the status of the right to a fair trial as a core guarantee on which other human rights rely for their protection and implementation, as Danae pointed out in her introduction. And we observe in the introduction that the most consequential area of fragmentation in terms of practice is in terms of remedies. And yet this is the area given the least attention by commentators and even by defendants and their counsel. So having hopefully shed some light on some of the key issues that have arisen in recent high-profile cases and that also arise in the jurisprudence around this fundamental human right, I end with a recommendation. When seeking relief at the international level, defendants and their counsel should have remedies at the forefront of their minds. Which remedies are available? Which ones are likely to be ordered by the international body? And what are the chances of compliance by the state? And for their part, international bodies should be clearer about why they are awarding a specific remedy, why quashing a conviction and not ordering release, and where their approach differs from that of other similar bodies. It would be helpful if there were reasons provided for that divergence. At the very least, clarity of reasoning on remedies will help to make the right to a fair trial more accessible, more coherent, and more meaningful to defendants. Thank you.
Thank you very much, Philippa, for a really insightful lecture and covering so many different subjects, and of course raising wider questions about general international law, not only in relation to the particular subject. I have a number just to clarify, yes, I have seen on the side a question as to whether there will be a the recording of this lecture. Yes, there is a recording and it will be available to the participants at a later stage. We have opened the Q&A. I had informed everyone at the beginning. Some people found it difficult to come in, but please feel free to start putting your questions on the Q&A function. We have some questions. I can perhaps start with the first one from the audience, and I can add some questions given that I have the privilege to exercise as a chair in any event. But in the meantime, please feel free to add your questions. So Murilo Lubambo has asked Philippa, how do you envisage the role of the home state, if any, in assuring the right of a fair trial? For instance, Ghosn has triple nationality, including Brazilian nationality. Would the classic framework of diplomatic protection suffice? And of course, congratulating you on
Yes, I see that. That's very kind. Thank you. And also for those who joined a little later, just to point out, the discount code is in the chat.
Oh, yes, again, yes.
If you would like to take advantage of that, because I think it's only valid for a couple of months, according to OPC.
Please use the discount code. It's on the chat function again.
Do not pay full price. So Murilo, thank you for your warm words and also for a very perceptive question. I mean, so you mentioned Ghosn's triple nationality, and I think he actually left Japan using his French passport, which was the only passport not taken from him by the Japanese authorities. And then, of course, he's ended up in Lebanon. So he has benefited in practical terms in terms of his fleeing from the jurisdiction from his worldly connections. But in terms of whether the classic framework of diplomatic protection would suffice, I would say a resounding no to that. And we see that over and over again, that diplomatic protection is unwieldy, it's slow, but most importantly, it is at the discretion of the state of nationality. And so often the state of nationality will not be prepared for various reasons to exercise diplomatic protection. Even if they do, that doesn't necessarily translate into the realization of human rights. We have the case of Nazanin Zaghari Radcliffe, who is being detained in Iran and is a dual national. And the UK, in a very unusual move historically, declared, I think over a year ago, that it was formally exercising diplomatic protection over her. And she's still, I think she's now under house arrest. And, she's still, and her family are still fighting for justice. Julian Assange, with his Australian nationality, there's been various appeals to the Australian government to exercise diplomatic protection. The Australian government has shown no inclination towards that. So whether you agree or not with the government's positions in these cases, the bottom line is that diplomatic protection is not a fruitful route in most cases for challenging alleged violations of the right to a fair trial. I mean, fortunately, we do have quite a well-developed human rights institutional framework, which doesn't rely on diplomatic protection in many instances. Of course, if you wanted to go to the ICJ, you would have to use diplomatic protection, but it's not relevant in many other bodies. But what you may have to do is show exhaustion of local remedies, which can also be challenging.
Thank you, Philippa. We have a question from Emma Ranglais. She's asking what research results you have found most surprising.
That's a thoughtful question. So it's 4 years and 1,000 pages, and I think something that seemed surprising 2 years ago then became relatively normalized after a while. But one thing that did stand out for me is that going into this research, I just assumed wrongly that the European Court of Human Rights in most cases would be providing the most protection. And that it certainly has the most well-developed jurisprudence. It has the richest jurisprudence to draw upon. I mean, 11,000 cases. But often we found it took the narrowest view of the protection of the right. And the right to appeal really stands out in that respect, that the European Court is willing to accept many limitations on the right to appeal that other international human rights bodies have outright rejected. So in the conclusion, we try in each chapter to set out fairly objectively, to the extent that's possible academically, fairly objectively what the different courts are saying. But when it comes to the conclusion to each chapter, we point out the convergences and divergences. And if there is an approach that we think is preferable and more protective of human rights in the spirit of Article 14, then we mention it. And it's surprising in how many conclusions to our chapters where they're saying the European Court should follow the example of the Human Rights Committee or the Inter-American Court, or maybe every other body which has taken a more protective approach to certain component rights. So that to me was surprising. But at the same time, its jurisprudence is vital and should always be considered.
Philippa, can I just perhaps ask you something connected to this? So have you noticed that perhaps there's a particular period whereby the court perhaps has become less protective or has taken a more narrow interpretation of Article 6? Or is it potentially connected to some backlash or by states, or the fact that perhaps there is perhaps some states seem to not be complying with certain decisions of the court, and so one strategy of the court might have been to just take a more narrow approach? I'm just asking.
So, I mean, that would make logical sense, but that's not what came out. It seems to go back decades. There's throughout the chapters, we refer to this really interesting document that was prepared by a committee of experts to the Council of Europe back in the 1970s that compared the ICCPR with Article 6 of the European Convention, and already then is pointing out the narrower approach that either the European Convention expressly takes or that they think it should take. And I think the court hasn't really tried to modify that from the component rights that we've looked at in response to, any state backlash or non-compliance. I think what the court has done, which is helpful, is that sometimes there's been confusing strands of its jurisprudence. And for instance, in the right not to be subject to double jeopardy, there used to be a lot of confusion about whether that related to the same conduct or the same offence. And at one point, I think sometime in the 2000s, the Grand Chamber just said, look, we know we've got 6 different approaches to this, and in this judgment we are going to define what the approach going forward will be. And then it is that, because it's the Grand Chamber speaking, and that's extremely helpful in terms of avoiding fragmentation and other courts knowing what the standard is that the European Court adopts. And maybe that is in relation to state backlash or complaints about inconsistency. But I haven't seen a move towards, certainly in, off the top of my head, in terms of the rights I've been looking at, I haven't seen a move that can be traced to particular state positions.
Mm-hmm. I think Simon's comment is perhaps connected in a way to your answer, my question. Do you think that the divergence and conflicts of interpretation between international bodies can be beneficial? Or do you think that greater harmonization is necessary or desirable? I suppose I would, yeah.
Thank you, Simon. I have a whole other monograph on integration and fragmentation in international law, beyond the right to a fair trial, but just my approach in general to international courts interpreting, developing, and applying the same rules, whether in treaty or custom. So I do have a personal and long-standing view on this, which is that I think ultimately similar cases should be treated in a similar way, and that I think coherence and integration and harmonization are desirable in international law, because it leads to greater predictability, which is so important when a person is facing their liberty or their life being taken away from their interpretation of the law, but also in a broader sense of just stability and credibility and confidence in the international legal system. But importantly, Simon, I think it's good to use the word harmonization, because harmonization doesn't mean uniformity. And I don't think that there should be complete uniformity, because these courts have slightly differently worded instruments, which we also deal with in each chapter, subtle changes in words between instruments that can have real effects in practice. They also have different mandates. They come from they have different parties. They come from a different cultural and historical background. And that's all, I think, to be embraced. And that's why we have regional bodies as well as international bodies. And it doesn't mean they have to do exactly what another body does. But what harmonization means is that when you do diverge, that you explain it and you justify it. And this divergence is because of this aspect of our functions, or this institutional framework that we're in, or because of this wording in our charter. And then it makes sense. And then everything exists in harmony. But that is not done as often as it could be. But I would say there's one instance in which I think divergence and conflicts are healthy. And that's when we're trying to work out what something means or how it should apply. When it's a process of experimentation and interpretation. Because it's almost like a laboratory. You have different views bubbling together, and then after a while, when they've all come out and they can be examined, and there's hopefully dialogue among the different bodies, then things can settle and a more harmonized approach can be taken. And just to give you a concrete example of that, I think the way the right to be present in terms of being a component of the right to a fair trial, the way it's developed never had a pandemic in mind. And I think now, with all our remote hearings, in the ICJ, in the magistrates court, this huge range of remote hearings and different methods of remote hearings. And I gave some examples of the failings in the Assange extradition hearing. We're in a process of great experimentation with how a fair trial can be conducted remotely. And I think that this process of experimentation, and I'm sure some of these cases are going to be brought to the international human rights bodies. I think some of them already are before the Human Rights Committee. We're going to have these bodies grappling with how you balance the right of the defendant, perhaps the rights of victims and witnesses to have that person in court as well, and how you balance that against the sheer public health concerns of a pandemic. So I think emerging out of that, and it will be probably a few years of different views, will hopefully come to a conception of the right to be present that will hold us in good stead going forward. Because I'm sure, once the pandemic fades into a bad memory, we've all gotten used to doing a lot more things online, and there are real practical benefits to some aspects. I mean, I'm sure we've got people who are outside of London watching this and participating in this. So we want to retain some of those benefits, but in a way that still respects the human rights of defendants and other parties.
And Philippa, actually, your answer just preempted the next question, which was what do you envisage that this pandemic has given rise to in terms of the practice of states and how it will develop and how it will have an impact on the content and non-derogability of the right to fair trial. You mentioned in your talk that the results of your book and your research, the conclusion is that you consider that public trial and the right to have an interpreter are derogable, but everything else is not. So I wonder how potentially the pandemic might potentially change this. Of course, perhaps not, but it's a fair question, I think.
Yeah, very much so. It's going to reshape so many aspects of our lives, and fair trials and what they look like, among others. So what is surprising is how few states have derogated from Article 14. Only 2 have derogated expressly. Many states have lodged declarations that they're derogating in a time of public emergency, both to the UN Secretary General and the European Court of Human Rights. But only 2 have expressly mentioned the right to a fair trial. And that's striking, because I think that means that states are trying to conduct fair trials, and they believe that they don't need to expressly derogate because they're able to conduct fair trials by modifying the way these component rights are realized, but not in a way that requires derogation from the right as a whole. And that's what, they don't need to derogate from the right to be present, because they believe that if they do it by video conference and there's a secure line to counsel, that it can still be realized. So, I mean, that's an interesting aspect. But I think there's all kinds of ways in which rights are being interpreted and applied in different ways. So I've just talked about the right to be present. The right to a public trial has definitely become much more difficult to realize. But as you said, that was already derogable. The one big challenge on the horizon is the right to be tried without undue delay, because we would argue that that is non-derogable. And of course, there's no standard time that a proceeding should take, and it all depends on complexity of facts and
circumstances.
Circumstance, conduct of the defendant and the prosecutor, and all kinds of things. But I think it's under enormous challenge, and I just gave statistics for the England and Wales, but I think that's happening all around the world. So we will be seeing a reconceptualization, I think, of what undue delay means.
Exactly. So I suppose you don't have to invoke derogation per se, but the content and the scope of the particular might change. And I think you're right that we will see more cases in the regional courts, perhaps, and some of them might have to deal with this particular question of how, in the context of a pandemic, where a derogation has not been officially made in relation to a fair trial. So let's see. I think we don't have other questions, and perhaps because we're very close to the end, I should stop here, because if I ask one more question, it's going to be a very big question about jus cogens. So I'll leave it there.
To be continued.
Yes, exactly. So thank you very much, Philippa. This has been an absolutely outstanding lecture. I'm absolutely interested in the book, and I will certainly use the discount code, although I have the 40% off as an
I know, but you can also discount.
But I definitely encourage everyone to use the code and read this book. It will definitely be useful both in practice and I do think in theory as well. So with all this, Philippa, thank you very, very much for giving us this lecture, and thank you all for attending and very interesting questions.
Thank you.